We're not going to be talking about the Construction Lien Act. What is it? Don't worry. If I started reading to you, Section 1 through 86, that would violate the Geneva Convention on Torture. So I won't do that. Instead, I've brought along three friends and experts who are going to have a discussion on what is currently happening with this statute and what might happen with it. You probably were very familiar with the debate in Ontario over prompt payment, the legislation that was proposed that did not go through, and then led to a commitment by the Ontario government to take a look at the Construction Lien Act. So right now, Bruce Reynolds and Sharon Vogel of Borden Ladner Gervais, a national law firm, have been hired by the Ontario government to take a look at this act and figure out what we do with it, to fix it, revise it, or potentially even scrap it and replace it with something better. We've all heard from Bruce directly that all things are on the table. I should say that each of my colleagues are involved in some fashion with many lawyer and industry groups, including the Ontario Bar Association Construction Law Section, and each of us, I think, are going to be reporting back in some fashion to Bruce and Sharon. So, as I said at the outset this morning, this is an audience participation seminar. We would very much like to hear from you, particularly with respect to real-world issues, problems, questions that you have that perhaps we can take on board in this process and report back. To start, however, to give our discussion some context and so that you can understand really what are the hot issues and where we might be going, each one of our panelists is going to be giving a bit of a presentation on certain aspects of the Act and the process that's currently underway. Now, we're all listed up here on the board, but just very quickly, of course, Glenn Ackerley is a partner with Weir Folds. He's been involved in many organizations over the years, including Toronto Construction Association, Ontario Bar Association, as I indicated. He is a lawyer who does a lot of different things, but one of the things he focuses on, and for today's purposes, I'm going to put him in this category, is he does dispute resolution. For example, he's currently involved in an arbitration process. So one of the things Glenn does is represent clients who are involved in a dispute. To his left is Yonni Fushman, who is a vice president and general counsel at ACON. Pardon me? Assistant, sorry. I've already promoted you.
He's going to ask for a pay raise.
Yeah, I know. Yeah, that's, yeah. So in any event, as you might appreciate in that role, of course, unlike someone like me who can really get obsessed in my practice with Construction Lien Act issues, Yonni has to be a bit more of a jack of all trades. So big construction company encounters all sorts of legal issues, not just liens, but that being said, liens is something that comes up, and so he will be presenting, I think, from the point of view of the industry and what issues are of concern. And then to his last but certainly not least, Ted Betts is a partner at Gowlings. And the slot that I'm going to artificially put Ted in for today is from the perspective of front-end lawyer, someone who advises clients on and helps with the drafting, negotiation of contracts. So at the very early stages of the construction process, dealing with risk from that perspective. Ted right now is the guy who is leading the charge, actually, for the Ontario Bar Association on what submissions we're going to be making to Bruce Reynolds in respect to the Lien Act. So again, I think Ted would echo my comments that we'd be interested in hearing what you have to say today as well after we've heard from these three gentlemen. So without further ado, I'm going to ask Glenn to take the podium.
Thank you. Thanks, Brendan. Brendan just mentioned I've just come off a couple of weeks from an arbitration that's going to continue a few weeks from now for some more weeks. But what we were talking about before the session over the lunch hour, talking about is the fact that the attorney on the other side of the case that I'm dealing with is from Alabama. I've never litigated anything with an attorney from Alabama before, and it's been a very interesting experience. They have a certain way of doing things. I will tell you a lot of Southern charm permeates the hearing. But in particular, it was interesting when I stood up the first time I had to speak at this hearing, I rose and said to the arbitrator, well, as my friend just said, which is what we lawyers do in Canada, we refer to each other as friends in court proceedings. I started to say that, and then I turned to Mr. Rogers and said, oh, by the way, up here we call each other friend in this kind of setting. And he said, wow, that's just wonderful. I hope we do become friends. And from then on, it's as my friend Glenn just said. Anyway, we're having lots of fun with that. So I've been tasked with the exercise of bringing us up to where we are now in terms of the Construction Lien Act. Kind of set the stage for some of the discussions the rest of the panelists are going to share, and also hopefully we get you engaged in talking about the problems with the Act, what we've experienced, what's been changed to date, what still needs change, and so on. So I'm going to give some context for the next little bit. And really to start, I was trying to think how to get reference to Brendan's grandmother into this talk. So maybe I'll say, well, back in the day when Brendan's grandmother practiced construction law, there was something called Mechanics Lien Act. Now, I don't know how many of you know or ever had to deal with the Mechanics Lien Act. I didn't. I was learning the law just as the change happened to the Construction Lien Act we're going to talk about. But prior to that, it was a Mechanics Lien Act. And in fact, we've got over 100 years of history in Ontario of having some statute of some kind in place to protect unpaid workers on construction projects. I was always a little confused by it being called the Mechanics Lien Act because I thought that had to do with auto mechanics and not construction projects, but I guess my confusion was shared by others, which is why they changed the name in 1983 to the Construction Lien Act. Of course, across the country, it's called other things in other provinces, Builders Lien Acts, and so on. So back in 1982, actually, there was a committee struck that had the lofty title of the Attorney General's Advisory Committee on the Draft Construction Lien Act. And they canvassed industry and assembled a group of very knowledgeable practitioners and industry leaders and came up with what became the Construction Lien Act of 1983. And some of the changes they looked at, and I think it's important we cover this because it's going to inform what we might see happen in the current review Brendan just mentioned. One of the things they looked at, for example, is the time period to lien. It had been, under the Mechanics Lien Act, 37 days. And they looked at it and said, does that still make sense? Does that time period itself make sense? Because when you think about it, back in the day, people would be paid, hopefully paid within 30 days. And if they weren't, they had a week to run off and preserve their lien rights. So 37 had a certain rationale. But then they realized, well, that's not enough time. Maybe we need a little more than just the 30-day payment window, so they stretched it out to 45 in the recommendations that led to the new statute. The amount of the holdback was 15% under the Mechanics Lien Act. That creates cash flow problems. You know, think about it. That means every invoice you send is going to be short paid 15%. You're only getting 85 cents on the dollar every payment, and that big whack of money accumulates over the project to the end. So they reduced that down to 10 to improve cash flow. And then another change was the fact that certain financial thresholds and calculations in terms of numbers, they realized had to be modernized. Some of you are consultants. You'd be certifying substantial performance on a regular basis, and you do the calculation. As we know, there's a formula, 3-2-1 formula, based on 3% of the first $500,000, 2% of the second, and so on. Well, back in the day, the Mechanics Lien Act was only $250,000 at those thresholds, so they doubled the amount. Now, what's the effect of that? It means you can achieve substantial performance from a financial perspective earlier in time, because you're dealing with larger contracts, and they felt there had to be proportion between the contract size and the calculation, so it's not out of whack. Because the lower the numbers, the closer to the finish line you have to be. So they looked at all these things and made these recommendations. Now, to put it in context, the time frame we're talking about, I was just curious. I looked back and realized that the committee meeting in April, the report came out in April of '82. The legislation came into force in '83. This was exactly the time frame Michael Jackson's Thriller came out. And then I thought, well, actually, for some of us, including me, that doesn't seem that long ago when it was out. So then I looked back and realized that Boy George and Culture Club came out with Karma Chameleon the same time frame. So that's how long ago this was taking place. So it's definitely over 32 years is a long time to have a statute as technical and important to the construction industry as this one is, sit there without getting some major attention. So what's happened since? Well, one of the most notable amendments I'll mention, there's been a handful. I'm going to touch on a couple. One of the most notable ones was as a result of a series of cases in the early 90s trying to figure out a particular section that requires, once you start a lien action, that one of two things happen. Either it is the lien action has a date that the court fixes for the trial date, or it's put on a list ready for trial. One of those two things has to happen. And the wording at the time said a perfected lien, that's one with a lawsuit underway, expires where no day is fixed for trial, or an action in which the lien might be realized is not set down for trial within 2 years of the date of the starting of the action. So basically, one of those things has to happen. Well, there are court cases that are saying, well, wait a minute, that word or doesn't sound like an or. When you read it, it sounds like an and. In other words, it expires where this or this haven't happened, means that those two things have to happen in order to satisfy the condition. So one of the biggest amendments back in 1994, I guess it was a statutory amendment that took out the word or. That's it. Like, that's the entire statute. Imagine going through the Queen's Park to pass a statutory amendment to take out the word or from the statute. So now it just says, if this has happened, then you're okay. So they took out the conjunction. So that's the kind of exciting amendments that took place over the history of the statute. One that was a little more significant has a more interesting story, I have to say, and that's the role of architects. I know there are some in the audience. But when the statute was passed in 1983, when it was updated, they received the submissions to remove architects from the Act, not include architects within the Act, because architects, I think, as I understand it, felt, perhaps understandably, that they're professionals. They shouldn't be subject to holdback retention. They should be, just like lawyers or accountants, able to bill their fees and get paid and not worry about construction lien rights, because lien rights are for unpaid workers, bricklayers, not professional architects. So they were removed from the statute, and there was a section in the 1983 Act that says, despite the section in the statute that would give them rights to lien, an architect does not have a lien. Okay. Well, that created a bit of a problem, because court cases came along and decided, well, engineers do have lien rights. And of course, often they're the subconsultant to the architect working for an owner. So the owner looks past the architect and sees an engineer, subconsultant, and says, I've got, under the statute, the wording of the statute, I've got to hold back money under the holdback requirements of the statute, the 10%, from the architect to protect that engineer if the engineer doesn't get paid. So as a result, architects got it both ways. They didn't have their own lien rights to pursue getting not getting paid by the owner and pursue a claim for lien, but at the same time they're getting held back against by owners because of their subconsultant engineers who did have lien rights. So they were caught in between. So as a result, they knocked on the door of the Attorney General and said, we're going to cave. We want our lien rights back, which they did in 1997. So that the section that I just read to you was deleted, and now they're in the same position as engineers or others providing services or materials to an improvement like everybody else. So since then, there have been a few other minor amendments. There was a section of the Act that clarified as a result. Most of these changes that happen are a result of a court case going horribly wrong, or some judge misunderstanding what the words of the statute were intended to mean, and coming up with a decision that everybody goes, oh, that's not what it means, and then going back to the statute making a change. And there is one like that with holdback. Just to clarify that the exposure of the owner is to the holdback exposure, but more importantly, if you post security, the security is limited to what your liability would have been even if you hadn't posted security. So all that got cleared up again through a couple of minor amendments. Since then, though, there are other court cases that looked at the language of the statute, how it relates to mortgages, for example, and how mortgagees and construction lien claimants, each of whom have an interest in the land, the property, their priorities, and coming up with decisions that have created all sorts of problems over the years. And then there was a section of the statute, most of you know that the statute has a milestone of substantial performance of the contract, as well as a completion formula. And that deemed completion, as we call it, is when the project hits, or the contract work hits a value of under $1,000 typically. The way that section reads, it's very, very unclear whether it was intended to cover both contracts and subcontracts, or just contractors alone and their contracts. You read it, and you can read it more or less both ways. So that required a court decision, Court of Appeal decision, I think, to decide that, we're going to read it as just being contractors that the section applies to in their contracts and not subcontractors. So you have courts stepping in to look at this statute as it was drafted and realize there's a problem with the drafting, whether it's the word or this kind of thing, and we're going to come up with some decision that tries to further the intent. But as this went on, bigger problems started to appear. And it became apparent, and industry realized that there are some fundamental problems, in their view at least, with the way certain key aspects of the Act operate. And as a result, and as early as 2000, so we're going back 15 years, there's this effort through industry associations like the Council of Ontario Construction Associations, for example, that is an umbrella organization, of course, of many other member organizations. They started to put together proposals for change, things they wanted to see changed in the statute. And I dug back and pulled out where things were at certain points. And one of them, one of the documents I came across, listed a number of things. I'll just touch on them because to this day they remain issues, as we'll see. The first is that there are trust provisions in the statute that require owners receiving money and contractors receiving money from owners and so on down the chain to keep that money and only use it for the project and not other purposes. And if you don't do that, you're guilty of what's described as breach of trust. The problem is there were no rules about where that money is supposed to be kept. So as a result, the money would come in on a project into the general contractor's account, as well as another project, from another project, and another project. It all goes into one account, and then the general contractor is paying out sub-trades from that general revenue fund. And as a result, it's quite possible that money coming in from one project gets paid out to a trade on another project. And that can create real confusion and has led to court decisions about all that. But the proposal, therefore, was to require separate trust accounts for every project being established. So that way a general contractor gets a contract to build a new project, opens an account for that project. This was the proposal back 15 years ago. That would help alleviate that problem so you much more readily can trace where the money is flowing. So that was one. The second one is the problem that the statute, I don't know if everybody appreciates this, but this holdback, and we're going to hear more about holdback later, but the statute itself requires owners to accumulate the holdback fund over payments, but doesn't require that it be paid out at the end. It actually says you may pay it out, provided there aren't any lien claims against it and so on. It doesn't say you have to. The have to comes from contract. The CCDC contract says the owner will pay the contractor after the expiry of the lien period the holdback, but that's a contractual issue. It's not a statutory requirement. And so one of the proposals back in the day that continues out there to this day is the requirement to have automatic dispersal, as they called it, of the holdback monies. That once the clock strikes and their 46th day, the day after the lien period expires, and there aren't any claims, then that money should be paid out. Well, that creates other problems because owners use that money, provided nobody's laid claim to it, for deficiency security, for other issues that are going on with the job. So absent having holdback on hand, they're going to have to find some other security method to secure against warranty work and so on. So that's the second big issue. The third one is one of timing for subcontractors. The way the Act works with general contractors is their lien rights continue so long as you have a general contract in place, a contract, until it's either terminated or you've finished your work. With subcontractors, it's the date you last worked. So if you're the framer, you're off the job, your work is done, partway through the job. There's still all the roughing and drywall and everything else to go on the project, but your job is done. If you don't lien within the month and a half following you packing up your tools and getting in your truck and driving off site, if you don't claim a lien, you lose your right for the rest of the project, even though the money that you're owed you may not see for another 6 months, or in some big projects, 3 years, perhaps, if you're the foundation guy. So the statute did include a mechanism for early certification of completion of subcontracts, as most of you know, but that really tends to be used, if it's at all used, and again, it's permissive, it's not obligatory. That's only used with early trades, the excavators and foundation contractors. So it's a problem for trades who don't want to lien and screw everything up on the project and create business ill will, but at the same time they're losing their rights. So one of the proposals that's still a live issue today is extending the rights of those types of trades, not to last supply when they work partway through the job, but to the end of the job, where everybody else's rights are expiring, same time frame. So if you're a painter or the framer or roofer early on, your rights expire at the same point in time. So that's a proposal. At the same, back, I was looking down the list in 2000, there were comments about adding things, improving the dispute resolution process within the statute. There is language about trying to make it a speedy process, but the moment you get a technical type of action like a lien action is in front of a court, we have a technical court in Toronto, but not elsewhere, you can get bogged down in months and months and months and months of litigation. It's very expensive. It's multi-party, class action type litigation. So certainly even then, the industry realized that some sort of dispute resolution process, aside from or as a supplement to normal course litigation, is important. And there were some other changes I won't mention that others were advocating for from various sectors at the time. So that was 15 years ago, some of the issues. Well, it hasn't changed much. There's been some refinement. So for example, moving a few years ahead, the account, having separate trust accounts for projects still remained a high priority. Other provinces have something like that. Maintaining separate accounts was a key issue. The dispersal of holdback, as they called it, releasing holdback, was important. And it's become more so as time's gone on, and people have come to characterize the owner's use of those funds as somewhat abusive. That they're taking money that nobody legally claimed through a lien claim process, and then taking it and using it, as I said, for other purposes. including just leverage. So there is certainly a sense of unfairness as the statutory provisions were put into practice. And in terms of the last one, the timing of lien rights, the theory is that I should have either my money or the ongoing right to claim my money, but not neither, which is what was happening. I got stuck on that sentence. And that's exactly what was happening. So by around 2005, as people continued to think and meet and talk about these various issues, there was a little more refinement and then a new development. The refinement was that there's a lot of pushback on the idea of separate accounts for every project, because just think about it. If you're a big contractor, as I know some are in the room, that's incredible overhead to manage a whole, open a new bank account every time you open a project. Similarly, for a small contractor who's got a bunch of small projects, it's also unwieldy. But for those, they recognized at least a minimum value of both project value, but more importantly, it started to be, let's put the holdback in a trust account. Not the whole project funds, although that was the original idea, but at least let's park the holdback so we know it's safe and sound, locked away. With exemptions for, the Crown, the provincial government and other types of owners. Then that started to create concerns about the lending community saying, well, hold on, we're not going to lend you the money at all, so why, there is no money to put away because we're not going to advance it in the first place. So there's clashes. Every one of these things has, I often think of it as, that game whack-a-mole. You whack one and another one pops up. Every problem you go to solve, and you do think you've solved it, creates another problem and another part of it. So this piecemeal approach to Lien Act reform, at least the suggestions, was becoming problematic. Then along came an interesting case. And this was the case, some of you may have heard about it at the time, called Kennedy Electric. And Kennedy Electric was a case about a massive, just a gigantic assembly plant that was built to build truck frames for Ford pickup trucks. And we're talking about the actual assembly line in what was otherwise a shell of a building. That assembly line took up 100,000 square feet, weighed 500,000 tons. It's a massive, massive collection of equipment. And the electricians and other trades who'd done all the installing of this, when they weren't paid, claimed a lien. And they assumed that they had lien rights. Well, the Court of Appeal thought otherwise, ultimately, and decided that there are no lien rights. As I remember, I think I did a commentary at the time. It's the Construction Lien Act, stupid, not the that was the Court's attitude, not the Construction and Installation Lien Act. And so this created a real problem with that part of the industry that does that kind of heavy industrial work. So that became another issue on the table, is addressing the consequences of that decision, because it represented a huge amount of work going on in the province, and those workers had no lien rights, even though they thought they had up to that point. So we've got, as of sort of late 2009 or so, we now got the ones I mentioned, the holdback, depositing the holdback into a trust account, releasing it upon expiry of the lien rights, continuing subcontractor lien rights, dealing with the effect of Kennedy Electric, and granting lien rights to those who thought they had it, but it turns out the court said they didn't. And then along comes the lawyers and the Ontario Bar Association, and they came up with a whole bunch of technical suggestions of the Lien Act, a couple of which really were problematic to do, and I won't deal with them in detail, but one had to do with the rules of which claims can shelter under which claims and how that should be addressed. And then another one had to do with the fact that the claim for lien form itself required that there be an affidavit swearing to its truth, be attached to it to be a valid form, and that was kind of overkill, we thought, and as a result suggested its disposing of that requirement. And then the other one I'll mention is the architects and engineers. I mean, they I think, shared this view. And the problem with architect, now that the good news is you're now part of the statute, you have lien rights, that's great. The problem is the holdback lasts from when you start your, schematic design right through all the design development contract documents to bidding out, to contract administration, to warranty work, and about 5 years later you get your 10% fees back. It's brutal for architects from a cash flow perspective, and so they want that changed. They want the statute to recognize that there should be breakpoints, key points along the way where they can get holdback release that's been accumulating. So they piled on with some suggestions, as did some other groups. The Sewer and Water Main Group, Association and others had suggestions as well. So that all got submitted to the Attorney General in late 2009. All these big issues. And after consultation and talking to industry and meeting with MPPs, and I was involved in a lot of this on behalf of COCA at Construction Day at Queen's Park, they finally put forward Bill 68, what was called the Open for Business Act 2010. And in that act, they did a few things that amended the Lien Act. This is the first substantive set of changes in all this time we've been talking about. The first thing they did, there was a technical improvement to the definition of home buyer that was very minor. But they did revise the definition of improvement, which I'll come to. And then they had the interior contractors, the finishing contractors have been concerned about condominiums. And I'll come back to that. They changed, added some requirements to do with condominium projects, dealt with the affidavit and some other procedural stuff, and that's it. There was nothing about the timing of lien rights, about release of holdbacks, all the other things that for the previous 10 years the industry had been harping about with good reason in some cases. So clearly it was a very minor win for the industry getting that changed, despite all the hoopla that, we're amending the act. Well, we tweaked a couple of things. Now, what was changed, as I say, that was important was the improvement definition of what an improvement is, a project, to address the Kennedy Electric case. So whereas before it simply talked about it being an improvement being an alteration or addition or repair to or construction on land, we've now added including the installation of industrial, mechanical, electrical, or other equipment on the land, it goes on, that is essential to the normal or intended use of the land, building, structure, or work. So, if you build for $7 million a shell of a building, and then for $44 million, as the case was, you put in a 100,000 square foot piece of plant, that work itself would qualify as an improvement because that's what the building was built for, was to house this plant. So now you have the possibility of leaning for that. And just a quick story, I was tracking at the time these amendments were coming into force, tracking the days, it's what we sadly, we construction lawyers get interested in doing. So I'm watching for this big amendment to land. And I got a phone call from an attorney in the U.S. who acted for a client who had supplied a printing press to a location here in Ontario, just north of the city. And he asked me, well, do you have the right to lien for that kind of installing a big piece of equipment, which is what his guy had done, supplied it and installed it. And I said, no, but interestingly, there's this Bill 68 that has passed, but we're waiting for word for it to be coming into force. And when it does, then you'd be in luck. And he goes, oh, that's too bad. And we hung up. And then out of curiosity, I checked with my librarian in the office and said, what's going on with Bill 68? She said, oh, it received royal assent, is in effect today. So I ran back to my office, picked up the phone, called this attorney back, and said, guess what? You're in luck. And this is all happening around 3:30 in the afternoon. So ignoring all the good, sound, prudent advice that you heard from Sandra and Brendan about how to look into lien claims properly before you register them, or the liability you may face, I said, how much is it? Let's slap it on. So that very day, we put on a construction lien based on this amendment that came into force that day. As it turned out, happy story, a happy outcome, the facility that they've been, the premises that have been worked on or supplied to, the landlord had taken over, saw the lien, said, how much is it? Okay, and wrote a check and paid for it. So it worked out great. I'm not sure technically whether, this was retrospective in effect or whether I had the right to do it at all, but it worked. Anyways, with that irresponsible story, we'll go on and talk about the other big change that happened in 2010 was condominiums, as I said. And the problem arose, I think, primarily from a case where contractors working on a condominium project, before it was registered, and then the units themselves created and transferred to the unit owners, the purchasers of the condo units. So it's at a point where the developer still owns the building. It's really more like an apartment building, as we all know at that point, rather than a condominium complex with separate ownership of separate units. At that moment in time, the contractor is owed a whack of money and had a falling out and left the site, was locked out, I think, by the developer, who then proceeded that very day to register and transfer all the ownership of all the units to all the purchasers. So the contractor came back with a big multi-million-dollar lien because there was a big fight going on, went to put it on title and realized, wait a minute, the unit owners now own the units. And the Act doesn't allow you to lien the interests of home buyers, if provided they qualify. You can't lien a home buyer. So you're left with nothing to lien. Now, it turns out there are a few units that were still hanging around, not transferred, they could pursue. Anyway, the problem was they didn't know this was going to happen. As a result, the Act in 2010 was changed to include a new notice provision. So now developers who are going to do what this particular developer did in this case, if they're going to do it, they have to first give notice, publish it in the Daily Commercial News, just like a certificate of substantial performance, with various pieces of information. They have to put that out there. It's called Form 24, and then within a period of time thereafter, they can go ahead and register. But they have to give the contractor and the rest of the world advance notice they're going to do that. So that was an important change. Now, since then, what's happened? Well, after this overwhelming set of substantial changes in 2010, the ministry said, okay, what about these other things you've been talking about? Let's consult with industry about those. So out they went with letters, and people were running around filling in surveys and making further submissions. And then things really got heated. The National Trade Contractors Coalition of Canada, the NTCCC, which is made up of trade contractor associations across the country, but in particular in Ontario, they're just, by this point, fed up with the lack of change, with holdbacks not being released, with payments not being made promptly. And Brendan mentioned this. This led ultimately to the Prompt Payment Act initiative, I'll call it. So they made the case that not being paid promptly was really cramping the industry, creating all sorts of cash flow problems, insolvencies, losing jobs, it put jobs at risk, all these good, important things. And a number of the states had this kind of legislation, has the kind of legislation we're talking about. Each number of states do. And so they decided to try and introduce it in Ontario. And the first kick at the can was on June 1st, 2011. A very short draft act, a private member's bill called Protecting Contractors Through Prompt Payment. And basically it said is pay within 30 days. If you don't pay, it's 18% interest, and people can stop work if they aren't getting paid and just go home. And it died that day because an election was called, and that was the end of it. But the spirit of it lived on. And then over the ensuing year or so, the various industry groups got together, started talking. Certainly the trades and the general contractors were talking, and came up with an outline of what would be a more appropriate set of terms. And that led to Bill 69, the Prompt Payment Act, which got introduced in May of 2013, but took until the spring, March of 2014, before it became, after going through second reading, it went to committee to be considered. By that point, the rest of the industry, or the world, woke up and realized, what the hell? What is this going on, this Prompt Payment Act? And so you had municipalities and other owners saying, where did this come from? You had government ministries saying, what is going on here? So everybody flocked to these hearings, and I suspect we'll hear a little more about that. I don't know if you want to talk about no, you don't. Okay. But there were a number of constituencies coming forth with comment. Some obviously very much in support of the notion, because the idea is, behind prompt payment, at least in this kind of form, is that payments are supposed, as the name suggests, it's not rocket science, supposed to be made promptly, but with some caveats. One being, if there are deficiencies, then it's a reasonable amount can be withheld for that. But also that holdback gets paid at the end promptly. So that would have addressed the issue I mentioned earlier. There's rights to information about what payments have been made and payments not made. And in terms of enforcement, the problem for trades is that generals say to them, hey, I didn't get paid by the owner, so I'm not paying you, too bad for you, right? That's very common arrangement, we all know. What this statute would have said is, that's true so long as the general is pursuing collection of payment from the owner. If the general sits back and says, oh, sorry, I didn't get paid, to the sub, then the sub can look to payment to the general. So there's an obligation to actually pursue the claim. Anyway, the home builders had issues with it for a variety of reasons in terms of timing. As I said, owners like the Association of Municipalities of Ontario had big issues, and some of the large contractors, and we will hear about this. I mean, the ACONs and Elistons and PCLs were concerned that what wasn't being addressed in part, and this is what we are going to hear about, is some of the problems of P3 projects, AFP projects. That's just, this statute doesn't work with that at all. It makes no sense. So there's a lot of problems. The OAA had concerns about certification processes. The Surety Association was concerned the way bonds would work in this regime, and the lawyers just had concerns over everything. So as a result, at the hearing, or just before the hearings are going to continue, the government said, whoa, okay, tell you what, we'll cut you a deal. We'll shelve this, but we're going to launch a reform. We're going to appoint some kind of review process, committee, something, that will look at these issues in the context, the greater context of Construction Lien Act reform too. So that was a deal. So they pulled it, and then what happened? We had an election in June. Of course, the government got reelected, and then we sat waiting for something to happen in the government to fulfill its promise. And then finally, earlier this year, as Brendan already told us, Bruce Reynolds got appointed to head up a expert review, and that's important. He's been hired with his partner Sharon Vogel to look at all these issues and make recommendations in his expert capacity to the provincial government, to the Attorney General, as to what should be changed, based on hearing from everybody, but also just his own perspective too, and research around the world. You know, how do people deal with these issues elsewhere? So the phase, what's going to happen is he's right now in phase one of the research collection of data kind of stage, and an information package is going out to interested organizations, parties who are participating. Then he'll accept input, comments, and then finally make recommendations, which are supposed to, currently at least, be made by the end of December. Then the plan is the government will reveal those, share them with everybody, and then eventually it'll lead to a revised Construction Lien Act, and as Brendan said, he's made it very clear that everything's on the table. So think about what we've heard about. How long should the lien period be? How much is the holdback? How much should certain formula be? There's really nothing about the Act that isn't open to some sort of improvement or suggestion. And all of this is on the table, including the issues that have already been raised by others along the way. So that's my overview of where we're at, and I'm going to pass it on. Yonni, you're up next. Yes.
Yeah. So I did start off as an American lawyer, but notwithstanding, I'd like to thank my friend Glenn and start with some opening remarks about Brendan's grandmother. I've been asked to talk a little bit about the modern kind of issues when we're talking about Lien Act reform and the Lien Act in general. What are some issues that don't really align? When the Lien Act came into force and Carbon Chameleon was on the radio when I was like 7,
Had to say that.
Yeah, you guys are old. It was a different world, and the issue with legislation, people that are proponents of legislation and let's fix everything by statute, tend to be very narrowly focused on their own issues at that particular moment in time. And what happens is the world changes, but legislation doesn't. So you've got legislation sitting on the books that, talking to some of the people that have been around in the industry, it's not like the Lien Act was like any piece of legislation, just everybody sits around the table, shakes, has a glass of scotch, and off you go. It's like a 5-year process. There's compromise all over the place. And watching the sausage get made is an ugly process. And at the end of the day, you have something that has compromise written all over it. And it's also basically addressing issues that people were complaining about 5 or 10 or 15 years ago. Glenn was reading through a list of 3 points from a memo from 2000, and I was in a meeting the other day as well where that memo came up, and we were looking at it, and the people, you're looking at the people that signed it, who some of them are no longer alive, and and the issues are actually, the discussion was, some of the people around the table drafted these points, and this is what they were digging in on 15 years ago, but the world has changed, and this is no longer necessarily what people want, but these things take on a life of their own, and by the time it becomes legislation, you kind of have to, it's like a Pyrrhic victory. It's like, what did we even do, right? We got something done. And then, so, in 1980 something, when this gets done, it's probably addressing 1975 issues. And then in the 1990s, we start seeing some P3s and more complicated transactions. Now, I'm in California in high school at the time, so this is all kind of by hearsay, but my boss, the actual general counsel, was responsible for drafting some of the legislation that set the stage for the 407. And so there's a 407, there are a couple of big hospitals that are done under this alternative model, but it's still very much by exception. Then, whatever it is, 8 or 9 years ago, Infrastructure Ontario comes in, they launch their version of a P3, they call it AFP, and they do a bunch of build finance jobs, and then we're off to the races. We've got dozens of hospitals done under full P3 model, and then in the last few years, maybe about 4 years ago, they started with the infrastructure projects. So we've had this explosion now where most of the major stuff that's getting built by the province is getting built in a model that was basically, for all intents and purposes, didn't exist when these debates were happening, 30 plus years ago. So what winds up happening is you have a statute that is the law and you have to deal with, but if you look at what happens in the world, the way contracts look for tens of billions of dollars of spend, and then look at the Act, you would think, like, what's going on here? This doesn't match, and there are some weird consequences of that. So to get a little bit specific about it without getting too wonky, the Lien Act has just a few definitions of a few different roles in the industry, and it's a very kind of CCDC, commercial contract type of world where there's an owner and there's a contractor and there are subcontractors. and the contractor is the entity that works for the owner, and everybody else works for the contractor. And that has a couple of the major consequence of that, as Glenn touched on, is lien rights. If you're the contractor and working for the owner, your lien rights run from substantial performance, which is defined by the Act, and then issuance of a certificate of substantial performance. But if you're a subcontractor, it's a much different regime where your lien rights don't line up to the end of the job, it's to your own work. So the first real problem when you try to line the Lien Act up with the P3 world is that's not the way it works. The first question is, who is the owner? So you have Infrastructure Ontario to the side as kind of the procurement authority, and they're assisting in the process with whoever the owner is. And maybe it's Metrolinx, maybe it's the MTO, maybe it's the airport authority, maybe it's a hospital or a school or whoever. So you would start off by saying, okay, well, let's call it, the government authority is the owner. But the government authority is giving a contract that's called a project agreement to somebody that's not what we would normally think of as the contractor. They're giving a contract to what's called in the industry the project co. And the project co it's a special purpose vehicle. It's a corporation that's formed for the purpose of this project as a funding vehicle. This is a project finance structure, which means that this is the major defining difference between P3 and everything else. Is in the everything else conventional world, whoever wants you to build their project, the owner, the government authority, pays you for that work, usually as you do it. Maybe it's on milestones, maybe it's monthly, but as you go, they pay you. They're basically self-financing it. The big distinguishing factor with P3 is that the government is ordering the work, and they're still the ultimate client, but you essentially are paying for it for yourself for some duration of time. Maybe it's just until the road is opened and there's an availability payment. The road is available, so the government will pay. If it's a full 30-year concession, the government might not pay at all, because you might be taking your payment from the stream of future tolls or concession revenue or whatever. So because of that structure, you form this entity that's a funding vehicle. You have to go out and raise money, and nobody wants to do it with on their own balance sheet. These are partial recourse deals or non-recourse. So all to say, you have this entity in the middle that's going out and raising money, whether it's debt, they're borrowing money from banks, or they're issuing bonds, or in a lot of cases they're putting up their own cash, their own equity. There's this new entity that gets formed that takes the contract with the owner, but it's only there for the purpose really of raising money and coordinating the payments. And coordinating there's the thing that has to get built, there's the construction side and the design of it, and then there's often the operation and maintenance side, and they're kind of tying it all together. This is not your traditional ACON where you hire ACON to build a building and then they build it and you pay them every 30 days or whatever. So that company actually will then hire an ACON or an Ellis Don, or typically now a joint venture of ACON and Ellis Don and whoever else, because these jobs are so big. So you've now introduced this entity into the structure that didn't exist 30 years ago, and the Act is not designed to handle that. Under the Act, technically, I think the authority, whatever government agency is still the owner, but this project co is the contractor, which means the actual contractor is now a subcontractor. Now, does that have any real consequence? Maybe not, because the Lien Act in some ways is highly irrelevant now. It would really matter if substantial performance meant something. Because that would mean that the contractor now is a subcontractor and their lien rights flow from date of last supply. But the overarching point is that the Lien Act is so irrelevant in this world that it's just contracted around for all intents and purposes. It's basically something you have to technically comply with, but it's kind of this this dead husk that's sitting there that doesn't do anything other than it's a law and you just have to deal with it. So substantial performance is just one point in like a 30-point list of things you have to do to get something that's defined as substantial completion. Holdback is another thing that doesn't really work, as Glenn kind of mentioned. holdback in the traditional world where the owner holds 10% of the contractor, the contractor holds 10% of the subs and on down, doesn't really work because the project company doesn't really have this 10% money from anybody. It's just they're not necessarily paying down to the contractor, but if you were to say as a subcontractor, hey, where is my 10% money? I'd like to see it in an account somewhere. There's sort of an idea of your money. There's like there's a commitment to make your money available, and in practice it doesn't really matter because the money really is there. These are all hugely solvent companies, and there are indemnities all over the place, and every one of these, 3 or 4 companies that are in joint venture, which are the biggest companies, some of them in the world, a lot of them are European, would have to go bankrupt before somebody doesn't have their money. So as a practical workaround, nobody really cares, but it is still so most of like 99% of the people involved in the deal don't care at all, except the lawyers kind of look at each other uncomfortably saying, so that lien act, huh? Okay, we're still doing that. So from our perspective, if there's legislation out there that we have to live by and there's an opportunity to reform the act and make it current, I don't presume to know exactly what the answer is, but there should be some discussion. I do think that Bruce Reynolds, from discussion with him, is looking at this of at least lining it up. Let's have the defined terms work so that there's not all this kind of ad hoc, like we're just gonna kind of make it up as we go along. I know P3 isn't necessarily relevant to everybody in the room, so I won't belabor that point. But in terms of modernization in general, jobs tend to be longer and bigger now. Things tend to get bundled. Dollars are higher. A lot of the spend in the industry is government. And so, not to repeat a lot of what Glenn said, but those are modernization issues with respect to one. You can only have one substantial performance date, which means one certificate of substantial performance, which means holdback release only happens once on the job. So on a 3-year job, you have this problem where the early works contractor, whether it's the excavator or whoever, has done the work, but their lien rights expire 45 days later. Their holdback isn't going to be released from the owner until maybe 3 years later, which introduces some perverse incentives to lien before, 3 years before you're entitled to your holdback release, or don't lien, which is really what happens, and just kind of see what happens at the end of the day and hope that you don't have a problem. So that's something that, there are a lot of potential workarounds. You could have multiple kind of phased substantial performance. What you could do it on a time basis, say every year we're going to do like another tranche so that we can release money. You could extend holdback or lien rights. There are all sorts of things that can be done, but the overarching point is something has to be done or should be done because it's just it doesn't really work now. And without getting into a holy war about Bill 69 and prompt payment, I think it's important to look at what some of the underlying issues are that lead to payment crunches. And one of them has to be, from the trade contractor perspective, that huge differential in time where you're basically just floating 10% or more, and you don't really have any assurances that you're ever going to get it back at the end of the day. And a lot of that has to do with, those comments have to do with lien rights, and I would just kind of pose maybe as a debate question, this is very much an ACON bias, but do we really care that much about lien rights anymore? Because a lot of the stuff that gets built in a big way, now obviously there's billions of dollars of money being spent in smaller projects that are real dollars that kind of aggregate, but if you look at big infrastructure and hospital projects, what's really the value of the lien other than in Toronto you get the benefit of a lien master versus a family law judge looking at your case. And there was a really weird decision recently about whether you can lien a subway. And the answer as of now, subject to the experts on the panel, my understanding is that yes, you can, subject to appeal of that decision, you can lien the subway under York University, which starts, you have to pull back from that a second and say, like, what? Like, because the whole reason to have a lien is that it's security. That's all we're talking about. It's like, you know, it goes back to if you're building a building for a private developer and they go bust and you know, their project finance and they're off balance sheet and they don't have any money, well, at least you can take the building and sell that and you can probably make yourself whole. What are you gonna do with a subway, right? what are you gonna do with the hospital or I mean, roads are different, but the same idea. Like, all of this stuff that gets built by mostly government agencies these days, there's not a tremendous value in it. And you know, I don't know. Maybe you guys see more of it, but I can't even remember the last time that we placed a lien and it was really worth something. Like, really, really, thank God we liened because now we got our money back. You do it because you get the benefit of the better process. You do it so you don't get yelled at by your internal executive saying, why do you lien?
Leverage.
Yeah, I mean, some leverage, and and in some cases it can maybe, it's a bit of a thorn in the side. It can slow down payment for a couple of days, but the reality is, like in Quebec, it's a real issue because it's really hard to bond off a lien in Quebec, really hard. In some cases you can't. So that's a real lien that just sits on title and really aggravates people. Here, you walk into court the next day, and as long as you have the money to pay for a lien bond, it's off title. And now it's more, you know, for anybody of any scale, it's just kind of a nuisance having to deal with a lien, and you've got to deal with some process. But from my perspective, there's just so much like consternation in the industry about liens and lien rights and holdback and all this stuff that kind of at the end of the day, it's like, it almost feels like we've lost the sense of what are we talking about. And that's why I know that some of the industry groups and Bruce Reynolds are looking at maybe the way to get money to flow is to improve the dispute resolution process, because what you want, if you have to lien, you don't want a lien, you want your money, right? You want the dispute resolved. And what a lien gets you is a lawsuit. A lien disappears if you don't start a lawsuit in 45 days. And then, you know, yes, a lien master is a better process than a regular judge, but it's still potentially hundreds of thousands of dollars and multiple years to get anything. And, you know, that's very much a Pyrrhic victory, and it's often just kind of negotiation by exhaustion and attrition. So, you know, I think if we're looking at an opportunity for reform, let's not obsess so much about, like, I don't know, it's sort of like redesigning a better Zeppelin, right? Like, technology has moved on a little bit. Let's think about what the modern state is, and what the industry really needs. That's all I've got. Ted?
Yeah, I would just pause to observe just very quickly. I was a little depressed during this conversation that all the references to the Lien Act being dated and the cultural references, all of them are more recent than the last time my beloved Toronto Maple Leafs won the Stanley Cup. So, that being said, that's a very well taken point, though, I think. You know, should we actually be looking at replacing the Lien Act with something else? And apparently that discussion is available in this process. So something to think about.
Just one other kind of concluding comment along those lines is that legislation, whether it's this legislation or anything else, is not a panacea, and it will not fix the industry. And just by way of example, and let's just stick with payment. Assume payment is your, the particular issue that you have. What happens if the reason that you're not getting paid is because you did a lot of extra work, so you're cash poor now because you did all this work that you say is a change, or the reason that you had to do it is because you were delayed? And these jobs, as everybody in this room knows, are horribly complicated. The simplest job is horribly complicated. And now, let's say you're going to get in front of a judge within three weeks because the process has been fixed so well, what are you going to tell the judge to convince them that you're owed this money? You're spending, let's call it on a light day, 50 grand on one of these schedule experts. The other side's doing the same thing. Now a judge has to look at this, all of these Gantt charts and all, a Windows analysis, and figure out what the hell happened and who should get the money. And that, I put to you, that is not going to be solved by any amount of legislation or no legislation. It's just the world is complicated, this stuff is complicated, and it kind of is what it is, and that's the game that we're into.
Yeah, thank you. Oh, go question. Yep.
If you're talking about construction, wouldn't you, because of modern society and everything evolving and big projects getting bigger and bigger, would it be an idea to create a Lien Act purely for the P3 project?
Or just exclude P3 projects from the Lien Act altogether,
Then
or something.
what you're saying is the best way to do is, the lien is there for protection, but the sort of residual effect of that is that the cost of trying to argue your case isn't worth the case that you're trying to argue.
It totally depends on facts and circumstances. Depending on your scale, I think most people have sort of an inflection point of where you're better off just closing the books on it versus moving on. I mean, certainly everybody could agree if you've got a $50 million issue, I don't think there's anybody that would say the hassle of pursuing it's not worth it. But definitely, no matter what the dispute is, you always factor in those litigation and pursuit costs.
But the education should be, and I'm just saying, the education should be higher, because a lot of people do lean on the Lien Act as sort of security for any project. They're not educated enough to know that this really is a process that really won't work for you.
They should have attended today.
Well, on that note, maybe we'll ask Ted then to weigh in.
Yeah, I was watching Brendan and Glenn over there as Yonni is talking about getting rid of lien rights and thinking of their litigation practices going bust and getting a little nervous. It does serve that industry, the litigators.
I'm not starving. I'm fine. Don't worry about it.
It certainly does seem to serve us as lawyers as an industry. Just picking up on a comment that Yonni made about on P3 projects, the group of lawyers seem to be the only ones who care about the Lien Act. They sort of huddle, talk about the Lien Act for a bit, and then carry on with whatever they were doing. I like to think of often the Lien Act often as in the family of law that will apply to any kind of work, job, project. It's often, especially on the bigger projects, it's often the crazy uncle you see once a year at Thanksgiving. You go and you talk to them for a bit, and as a token of gratitude for being there, but then you don't really understand what he's saying, and he's not quite relevant to the rest of the things that are going on in your life and the family, and so you stop talking to him and he sits in the corner after that, and you carry on and have your dinner. And that's often as it is, but that itself creates problems. The fact that there is this piece of legislation that's there, and this is my act. It's a fairly thick thing. This is actually the second one in the last couple of years, because my other one fell apart. This is actually this is an annotated version of the Act. That's probably the Act. That's the case law about the Act. Trying to figure out how we understand this thing, how it applies to all these unique situations that we didn't think it would ever have to apply to. When the Prompt Payment Act was starting to kick into gear, and the private member who had sponsored it started having some meetings and invited some government people to speak first at it. I was at one of these meetings, and she was from the Attorney General's office, and they're the ones that oversee the Construction Lien Act. And she made an interesting comment, which I remembered and I wrote down, and it's very important, I guess, to reflect on that now. She said, as you're talking and consulting and among yourselves about the prompt payment legislation, Bill 69, I invite you to kick the bear and consider some reforms to the Construction Lien Act. So they were already thinking about this and asking, sort of yearning for the industry to come forward, I guess, and almost like they were looking for an excuse. And the prompt payment discussions really brought out a lot of, I guess, consensus, at least consensus that there was some need for change, because the industry has changed in so many different ways. And you only talked about one. I'm going to talk about another in a minute, but it's it's a kind of a one-fit-all kind of solution that doesn't apply to all sorts of projects, from the very biggest, but even to the very smallest. I mean, Brendan's on a personal campaign about the impact, adverse mostly, of the Lien Act on home renovations. Because it applies to every improvement, no matter how big or small, and it really doesn't fit. And so because it doesn't fit, a lot of the times the solution is just to ignore it until you've got a problem, and then you go back into the Act and it becomes a sword. Instead of a shield to protect contractors and make sure they get paid, it now becomes a sword that's used to attack and get payment or extract agreement on issues that people don't agree on. So it's a bit of an odd beast. It's functional. I think like we've set up here, it was a result of compromise, and like every compromise, it left everyone unhappy a little bit. But we got used to it and find our ways to work through that. I'm going to talk about two issues that sort of bug me about it, and I'd be really happy to see changed. One is kind of a very niche sector of the world that touches on the Act, but touches on many parts of the Act. And the other is a small, I guess, one part of the Act that affects every project. So the first one, it touches on some of the same issues Yonni talked about with infrastructure, but companies have evolved from the strict construction company that used to, or the guy you called up and came and did your, started building your home, or built your office building, or whatever the facility is that you had them build. Companies that build things do a lot of other things too now. Aecon's a great example. They provide construction services, construction management services. Some companies will be design build companies, have engineers on site. But then also beyond that, beyond strict construction work, they'll provide operational services. They'll have all suite of services and solutions, advisory services, consulting services. So you'll often have companies who get hired, and I'm thinking in particular, as a good example, property managers or facility managers. And I have a number of clients who run buildings now. That's a very big industry that didn't quite exist. You owned your building and you maybe hired somebody to do some of the janitorial, and you went and hired somebody to do the repairs when you needed them. Now there's whole industries of companies that will run your office tower for you, and they'll run many office towers. Now they'll get paid a retainer or a monthly fee, and in that monthly fee will be a bundle of services that they have to provide each month, and some of those services will be janitorial, and that the Lien Act doesn't apply to that. Cleaning up and security, the Lien Act doesn't apply to that. Some of it will be repair. Now we're starting to get into the Lien Act, and some of it will be actually more major repair up to a certain amount, and then at a certain amount they'll go out and actually hire somebody specifically. Or even that property manager will be tasked with subcontracting out major pieces of renovation or construction. And so you've got a mix of payment streams, because they've got a retainer and now they've got some reimbursable costs, operating under a sort of master agreement or a facilities agreement that, again, isn't really thinking about the Lien Act and how it applies. They're looking at, what do we need for this building to operate? How do we keep this running properly for our tenants and the users of the building, as opposed to how does it fit with the Lien Act? And often it, like with P3 projects and in other examples, it doesn't really, and it only does after the fact, when we start to think, okay, we've got a problem, now let's look at what we did. And so, I'd like to see some recognition in the Act for these different models of service delivery, and some clarity on how we might deal with that, or if we even can. So I think there's all sorts of service industries that have come up that are borderline construction, relate to work on premises that cross over the line and into improvements without even realizing it. The other one I want to talk a bit about is the holdback itself. And we talked a bit about it, but I mean, there's a lot of issues with the holdback and the lien period. I think anybody who's dealt with the end of a construction project is familiar with this dangerous dance we play at the end. You've got the 45-day clock that starts to tick. At the end of it, as a contractor, you're going to lose your lien rights unless you lien. But you have all these issues outstanding. There's change orders and deficiency claims, and you feel you haven't been paid, and you know you're going to lose your lien rights if you don't file. So what are you going to do? You're going to file to protect yourself. At the same time, we've got the owner looking at it and saying, I'm not going to pay until all of these issues are settled, and I know I don't have any issues. I'll use the 10% as leverage, but I've got deficiencies, and I know my tally says you're going to owe me way more than the 10% anyway, so I'm not going to pay it to you. So I think we've touched on it a little bit up here. To me, it just seems there's got to be a better way, and in fact, a lot of different jurisdictions that I've looked at do deal with it differently. There's recognition of different size projects for the different amounts, different types of reasons you're holding back. If it's for employee payments in Quebec, for example, they distinguish between holdbacks for employees and the company itself. There's also the holdback itself. Mentioned here, it's really not really properly called a holdback because it's really just an absence of a payment. But the owner has to do that, and that impacts the cash flow. There are all sorts of jurisdictions that allow alternate mechanisms to satisfy that holdback obligation, and in fact, in P3 projects, and one of the reasons, I think we think in the P3 industry we don't really need to worry about the 10% holdback is because we've got so much other security on the project as it is, that there's never really a concern that the payments won't eventually get there. And so what we don't allow in Ontario is somebody to post a holdback bond. I mean, I have lots of American construction companies who come up and say, well, why don't I just post a letter of credit for that 10%, and that's cheaper for me and better for my cash flow on the project. And so we don't allow that. So that would be an easy solution, just to find some other way to deal with that holdback. And as you start to go down the list, you'll find all sorts of little ways we could tweak the act or really take a different stab at it to make the project work better, so that we can get to, so these don't pile up as issues and swords, and we can get to those issues that are complicated and really do need to be worked out, as Yonni was talking about. We're always going to have disputes about whether the work was done properly or not, but we get caught up in the technicalities of the act often, and as a result, a lot of the time we just simply ignore it and try to pretend it doesn't apply until we're really faced with having to deal with it.